Yeah, okay, this is an interesting one from one of the employers. I hired an HR consultant on a fixed term contract as an outsourced consultant, which lasted 15 years and then terminated his service in terms of the agreement. I am now taken to the CCMA for unfair dismissal. I want to know, is he an employee?
It's not an easy question to answer because the information seems to be quite contradictory that we're receiving because he's hiring him as a consultant, but he's an employee on the other hand. So it's difficult to ascertain, but there are certain tests you can look at depending on the salary of the employee. If the salary earned below the BCA threshold, it's about 21,000 Rand a month, just a little bit over it, then there are certain factors you can take into account in terms of the actual looked at the control tests. And if the employer provided tools of the trade, if it's only income, there are 8 factors that take into account. If any of those factors are present, it's presumed that he's an employee. It's a rebuttable presumption. In other words, the employer can disprove it. However, if the employee earned in excess of that threshold, then a different test applies, what they call the dominant impression test. And that basically means taking into account all the factors. What's the dominant impression that you get if it's an employee or a contractor? And those are the tests that will be applied at the CCMA or at Labour Court, depending, to determine if it was an employee or not. From this information, it's very difficult to make that call.
And then the fact that the HR consultant was hired on a fixed term contract.
Yeah, it does seem to reek of employment rather than an independent contractor, because independent contracts are not normally on fixed term contracts. They have a contract that can be terminated on notice, like any normal commercial contract.
But then I've also never heard of a fixed term contract that lasts for 15 years.
Correct.